numbers are right from the sign, there's probably going to be around 21 odd people, which I think we can probably fit around the table. Not, you don't have to sit here, but you're welcome to sit around. That way maybe you'd be able to hear me. Hi there. I think we're going to wait about another 5 minutes. They say it's supposed to start at 4:30, so just relax, talk to your neighbors, introduce yourselves. Maybe you'll see yourself in court one Thursday.
What is the
Commencement
commencement time?
time for this?
Yeah.
4:30.
I mean, what's the, what time are we going to
When you get tired of me. So it's, my guess is somewhere between an hour and a half. No, it won't be more than an hour and a half, because I don't think I have an hour and a half worth of stuff to tell you. But that's where it's scheduled. If you need to leave early, do not be shy.
No, I don't. I just wondered.
Yeah. And I think they have a program to us 3 to 6, so there'd be there's the plenary session downstairs and the breakouts up here for an hour and a half. And it'll sort of be depending on what the group wants to talk about and what questions you might have. So. Hugo, what are the colors that we use for the appearance in the withdrawal? What colors are they? Do you recall?
I know one is ivory colored and one's salmon colored, and I'm just trying to remember which one is which.
I don't remember which one's which.
Depending on what I'm doing, but
Hugo, you pronounce your last name Nikkei? Nikkei. When do you want to get going?
I think it's just about time.
All right. All right, why don't we get ourselves going here? The sooner we begin, the sooner we can complete this. My name is Jeffrey Winnick. I am the first justice of the Housing Court sitting in Boston. And to my right is Hugo Nikkei, who is from the Boston Bar Association. And Hugo administers the Lawyer for a Day program, the LAR program, in the Housing Court, and especially on Thursdays. He's the go-to person administratively for Thursdays. Now, I believe what is intended for this session is to talk with a little bit more specificity about LAR representation in the Housing Court. And that includes two pieces. One is going to be the mechanics of what you do on a day. Typically, it's going to be a Thursday, which is when most of the Lawyer for a Day and limited appearance representation, at least, is initiated. How that works, and Hugo is going to talk about that. And I will spend some time talking to you about my perspective on LAR, things that I see from sitting on the bench as I do, things that you might be able to do to make it clearer what you are doing, to make it more successful what you're doing. I don't see this as a portion of the program where we're just going to lecture at you. At least I hope not. As you can probably hear, my voice is on borderline failure right now, battling a cold, which Joanna Allison would probably say is my just reward for having taken a vacation last week. So I'm hoping to give you a chance to ask us questions and to get you to focus on what you think you want to do. Let me just start by telling you right now that I'm very impressed by the turnout here. This is quite extraordinary, and it speaks well to you and to the Boston Bar Association in terms of how effective a job the bar is doing at getting lawyers to participate. I've always believed in my years on the bench that there is a difference in the quality of justice that is dispensed depending on whether someone comes before a judge with a counsel or without. A litigant with a lawyer by his or her side does better. I think that if we ever ran the numbers qualitatively, I think that it can be proven that cases that otherwise wouldn't be settled do get settled. Arguments that otherwise would not be made get made, and that the end result is a resolution that comes far closer to what might be termed fair than what we see when a pro se unrepresented litigant is left on their own. It is not perfect, and I don't want anybody to think that the limited appearance representation is a complete replacement for full representation. It isn't, but it is still better than not having it. And the fact that we're spending time here talking about limited appearance representation should not be a reason not to think about taking full representation in a case if you want to get the full experience. Or maybe situations where you can do it. And to the extent that you're able to, I want to encourage all of you to consider taking a pro bono case in the housing court on full representation. But that's well beyond what we're going to be covering here today. What I'm going to do is, and at sometime early on in this process, I hope that we'll just be able to open up the floor to questions, and that the focus of the rest of the presentation will be on what's of interest to you, or what's of concern to you, or issues that you'd like to get some sense from me or from Hugo about. With that, I'm going to turn it over to Hugo to talk about the process that gets you into my courtroom, and then I'll talk about it once you've entered the courtroom.
Great. My name is Hugo Nakayam, staff attorney at Volunteer Lawyers Project, and it's a great pleasure and a great deal of fun, honestly, to work through the Boston Bar Association's Lawyer for the Day program, and to, especially in housing court, where I think both the court staff and the judges are extremely understanding of the LAR process and of our pro bono Lawyer for the Day project. So I can certainly give you information about the perspective from coordinating volunteers who are doing pro bono Lawyer for the Day, particularly with regards to summary process evictions and some civil matters between landlords and tenants. I may not be able to speak as to inspectional services issues or fire department issues nearly as much, or criminal matters. But one brief word about conflicts of laws. If there's a conflict between what I say and Judge Winnick says, the judge is right. So
until the appeals court tells me otherwise.
So yeah, I think many of you have most of you, I hope, have attended the earlier session on the general LAR issues and best practices. If not, I believe the video will be on YouTube, so please check that out if you haven't. Also, for volunteers who wish to volunteer through my organization, the Volunteer Lawyers Project, we strongly encourage you to have at least attended one substantive Housing Law 101 class or have some equivalent experience. We just held one last Thursday, and we should have another one in about 2 months. So you can visit our website, www.vlpnet.org, if you're interested in that sort of thing. But, of course, this is to be more general as well. For those of you who are in private practice and wish to incorporate LAR into your practice, there's definitely way more pro se litigants, as I'm sure the judge can tell you, than we're able to handle through ourselves and our volunteers. So there's definitely a market there for the private bar to step in and do some good work and really make a difference on cases while making a living doing so. Particularly with many of the statutory attorney's fees provisions in many of the claims that may arise in, at least on the tenant side, on a housing case.
All right. I'll just jump right in then and talk about the court case. How many of you, just by a show of hands, have been practicing for 5 years or less? All right. For those who are listening to this, the vast majority of the people raise their hands with a few outlier exceptions. I would venture to guess that most of you have civil litigation experience that doesn't include a significant amount of on-your-feet courtroom experience. Back when I was young, I cut my teeth in the Suffolk Superior Court motion session, where every day of almost every week you could get to hear great advocates, and you could also get a chance to learn how to do it. With 9A, a lot of those opportunities have withered, and a lot of younger lawyers do not get the experience that lawyers from a few generations ago got every day. And as a result, people have different perceptions of what a courtroom is. The LAR experience gives you an opportunity to actually get on your feet, stand up before a judge, and advocate. It doesn't matter whether it's a big motion or a little motion, whether you have strong facts or weak facts. It's going to give you a chance to get up there and just do the things that you've been talking about in law school in the early stages of your career. In the housing court, it's going to give you an opportunity to do it with judges who are going to be a lot more understanding than you otherwise might receive because of the nature of the program. We know who you are, we know why you're here, and we know you've had 5 minutes to prepare for some of the motions. Limited appearance is just that. You've heard about it in the last hour. It's you've agreed to represent a client for a specific task, be it a specific issue or a specific motion. Once you've filled out all the paperwork and you've talked to your client and you've made sure that your client's agreed and you've gotten informed consent from your client, all the things that happen outside, and you come in, when your case is called, make sure when you stand up with your client, you let the judge know that you are here appearing on a limited appearance representation. There are 2 forms that you heard about, the appearance form and the withdrawal form. I would be very rich in the first year of LAR every time someone gave me the appearance form and the withdrawal form at the same time. You create an existential problem when you do that. You cannot be in and out at the same time. Make sure you give the appearance form to the clerk. You can ask before you approach, may I approach to file the limited appearance form? I'll always say yes. You give it to the clerk. Hold on to the withdrawal. Do not put it in. You are now in pursuant to the housing court rule, which mirrors almost in its entirety the SJC rule for limited appearance. There are no hidden traps in the local rule, in the Housing Court Department rule. We just adopted it in mass. Do not presume that the judge is going to know what the scope of your appearance is, meaning what issue you're going to be arguing. So tell the judge, Your Honor, I'm here on a limited appearance for the purpose of, and just let the judge know what that is. It could be on a motion to vacate default judgment. It could be on a motion for summary judgment, a motion to dismiss. I'll go over them in a little more detail in a bit. But just let the judge know, because a few things will flow from that. If the judge knows that you're here on a limited appearance representation, the judge will then know that, at least the judge has to decide, is the judge going to make a decision from the bench that day? Or if the judge takes it under advisement, the judge will know enough to at least inquire of you, are you going to be withdrawing your appearance before the court renders a decision, or are you going to keep your appearance in until the court makes an appearance? So that's always helpful. Second, if you've agreed to represent a party on one motion, be careful when there are multiple motions on the list for hearing. I sometimes conflate things, not intentionally, just because I'm thinking fast and I'm thinking ahead. And while you're still talking about the motion to dismiss that you've entered a limited appearance on, I'm asking questions about the motion for discovery or the motion for summary judgment that also is sitting there in the file. So don't be shy. If the judge starts asking you questions about a motion that you haven't agreed to appear on, tell the judge, Your Honor, I can't respond to that. I do not have an appearance to argue that. My appearance is limited to this issue. I will pull back and I'll try to restructure what I am doing to make sure that I don't turn your limited appearance into a general appearance. And what you need to understand is that from my perspective, this is not a game of gotcha. My goal is not to walk you into a general appearance. I will not do that. Even if you start talking about a issue that is beyond the scope of your limited appearance, when you realize it or I realize it, I'll give you the opportunity just to step back from that. So don't worry about walking on eggshells. That is not how limited appearance representation is handled in the housing court. But the importance of all this is that your client needs to know with clarity what you're helping the client with and what you're not. And sometimes, even in the course of a limited appearance where you're on for a motion to vacate, if another issue arises, if you're not sure whether you want to represent the client on that issue, or at least you want to talk to the client, just ask me. And I'll simply take a recess or put the case on second call so you can have a conversation with your client to clarify the scope of your representation. Maybe you're going to want to enter an appearance for that second issue. But I don't want you to feel that you're stuck and you have to do it simply because the topic got raised in the course of the initial oral argument. But you need to lead me on that. You need to let me know. And as I said, I and my colleagues who sit in the housing court will be open to making sure that what you're doing is confined to what you've agreed to do. Now, the arguments in the housing court are that you might enter an appearance on can be varied. Typically, I didn't mean to be flippant when I said it earlier, but sometimes you'll meet a client at 10 o'clock and you'll be arguing a motion at 10:30 without a tremendous amount of time, or any time for that matter, to do factual investigation beyond talking to your client, without necessarily the ability to do any legal research beyond what you can glean from Hugo and the other lawyers who are manning the volunteer lawyers table. But that's okay. Now, you do the best that you can with the knowledge that, one, is going to be far superior to what your client would have been able to accomplish without you. And second, I know that you've had 5 minutes to prepare. So I'm not going to sit there and ask you questions to see whether I can push you into a statement that you didn't want to make. I won't do that. I'll hear you. I may ask you some questions, and they may be questions on issues that you hadn't thought about. And if you hadn't thought about them, you're not sure of the answer, simply tell me, Judge, I hadn't thought about that. Can I have some time to consider it? Now, the time might be 15 minutes to go outside and talk to one of the more experienced lawyers, but it also might be that I'm going to want you to give me a more probing response, in which case I might give you, if you ask for a week, I might give you a week. If you want to do some research on an issue, to come back with me with a response. But if you don't ask me, then I won't know that you need the assistance. Other thing that you should need to know in limited appearance representation is that I treat most motions as conversations with lawyers. I'm interested. I'm intellectually interested in the issue and what you have to say, and I love the give and take of the oral argument in courtroom. So I will be sometimes asking you questions. I'll sometimes, almost always, be interrupting you. You should treat your appearance as a conversation, albeit a more formal conversation, hopefully a polite conversation, but nonetheless, you're engaging me in a focused discussion. Tell me the issue. Tell me the facts as best you know them that are relevant to the issue. And tell me what you think I should be doing. Judge, we're requesting that you vacate the default because, and then go back and fill in the gaps. What my client wants. Now, if your client wants 2 weeks, they have another place and they just need 2 weeks, don't spend 15 minutes talking to me about why I should vacate the default. Talk to me about what's the ultimate relief that your client is looking for. It's very practical, and you may find that you are going to get exactly what your client wanted with a minimum of fuss. Other thing in LAR motion practice, take the opportunity before you come into the courtroom to at least seek out the lawyer representing the other side. You'll know what your client's looking for, but you may not have had the opportunity to find out what it is the landlord, if that's typically you're going to be doing LAR appearances for tenants, occasionally it's for landlords, but find out what the other side wants and sound them out about what your client's looking for, because you might find that you can get agreement that that your client didn't think was possible because your client didn't know to ask and be prepared to do that. The type of motions that I typically see LAR appearances for in the housing court, and I wrote a list down here, I'll just sort of run through them. As I said, motions to vacate default judgment. The tenant didn't show up on the original trial date and was defaulted. Always remember, there are 2 things that I want to hear when you're arguing a motion to vacate default. I want to know what the reason was, why your client didn't come. There are almost never very good reasons. You know, but nonetheless, it is the reason that you got. Don't try to mask it. Just tell me. If it comes down to, I forgot, that's what it is. And the little hidden secret is, if you actually have a pretty good defense, I forgot might be enough to get you through the first level. So don't be embarrassed by it. Just acknowledge it and then focus your attention more on the merits of the case. But the second part of any motion to vacate default is that there's something that you would have to present on behalf of your client that has some credibility, some possibility of merit, were it to go to trial. No one's going to give you much time or consideration if it's a eviction for non-payment of rent, the tenant owes $10,000, and that's nothing else. Tenant just didn't pay it. You're not going to get very far. So think it through. One, why weren't they there? And then two, what's my client going to be telling the judge if the client gets a hearing on the merits? The stronger you can make the merit argument, the better chance of success. Understanding that you're probably not going to be there to represent the client when the case comes back for trial. You might be, but it's going to be your choice. But the scope of your limited appearance is going to be limited to getting the bell unrung, vacating default. You should also always be thinking about the ultimate question. How should this case be resolved? Because even if you prevail on the motion, it may end up being a Pyrrhic victory if you can realize that by the time it gets to the trial, your client's likely to lose. Or even if the client gets a partial win, they're still not going to be able to comply with any of the orders that the court might issue. So the question you still need to always be thinking about, what's the best way to resolve this case? And perhaps getting the default vacated puts you in your client in a better procedural posture to try to ultimately settle the case. But don't lose sight of the ultimate goal for a short-term win. Be thinking about them all together. Other types of motions. Motion to dismiss. Slightly more technical. That's going to focus on something that is concrete in the papers. It's got to be something that you can see on the papers or that you don't see. For example, you don't see a notice to quit. Judge, the tenant never got a notice to quit. Was never served. Now, it's going to be denied if the landlord stands up and says, yes, I did. I served I either had my constable serve the tenant or I gave the tenant the notice in hand. That's factual. So you're going to have to ascertain credibility to make that determination. But on a motion to dismiss, look for the argument that enables you to stand up and tell me, accepting the facts in the light most favorable to the landlord as set forth in these papers, the landlord still can't prevail because the notice that the landlord is relying on is defective on its face, and tell me what it is. Or under this subsidy program, there were certain steps that the landlord needed to take in order to properly terminate this tenancy. The landlord didn't do it. The notice didn't include this language, or the landlord didn't send the notice to that person, whatever the case may be. How do you find this out? When you're there for the first time on a Thursday and you just get this client. The way you find out is you consult with the volunteer lawyers who are there to mentor you and work with you. But before you can have that conversation, you need to sit down with the client to see what they have and perhaps try to see the file. And on a Thursday, that is not an easy thing to do because we have 180 to 200 cases on a Thursday list. The files are usually held by the clerks, and the clerks would sooner chop your arms off than let the file out of their hands. So what you need to do sometimes is perhaps talk to the lawyer for the landlord and ask to see the copy of the lease or a copy of the notice that they're relying on. See if you can get their cooperation. Very practical way to try to do it. But coming in to me on a motion to dismiss, the more it sounds like there's a dispute of fact, the less likely I am to grant the motion. So frame your arguments in terms of accepting everything in the light most favorable to the landlord. Summary judgment. Summary judgment is more difficult to do on the day that you take a case. But sometimes your clients have filed these pro se motions for summary judgment. Usually it's dashed motion to dismiss / motion for summary judgment because if in fact I have to take a look at evidence that are outside of the pleadings, technically it looks more like a summary judgment motion. That encompasses a situation where you want me to take a look at the notice to quit, or you want me to take a look at the lease. On a summary judgment motion, I might, if requested, give you more time to give me an affidavit or a supplemental affidavit. But before you come in and talk to me as an LAR attorney, think through again what it is that you want and why you're not ready to do it on that date, the day of the hearing. I'll listen to you. If it makes sense to me, I'll typically try to issue an order that gives you time to do it. But if I sense that it's just for the purpose of delay, or I sense that it's an argument that you can make without a supplemental affidavit, or you can go out into the hall and get your client to prepare an affidavit in 15 minutes or 20 minutes, I'll give you the 15-minute or 20-minute delay to get it done. But again, think through what it is that you're asking me for. You will likely do hearings on motions to issue execution. Comes up very often in the housing court. The parties have reached a written agreement some weeks or some months before. The landlord believes that the tenant has not complied with the agreement. Brings a motion to issue execution. The tenant comes in, even if they had been represented at the earlier stage, they're not necessarily represented at the stage where the motion comes in. They come in on the day, they go to the lawyer for the day table, and we have, you're there, and you have to go in, and you agree to come in on a limited appearance to defend against the motion to issue execution. You will not know whether that motion is going to be heard simply on oral argument, or whether it's going to be whether you're going to need an evidentiary hearing. Frankly, these are terrific cases to get your feet wet conducting an evidentiary hearing on little, if any, preparation time, where, especially if it's a motion to issue execution based upon some behavior-based issue, and you have typically your client as a witness, maybe you're friends with that with your client, and the landlord or the other side is there. So it's a two-person mini evidentiary hearing. But for LAR representation, in the time that you have, think through how you would like to present it to the court, and if you think you want the judge to hear evidence, even if the judge wasn't thinking that it's going to be an evidentiary hearing, ask the judge, Your Honor, I'd like to present a witness, my client. I'll let you. If there's a factual issue that I need to resolve, to get to the merits of the motion. But be prepared to go in either direction. Oral argument based upon a proffer that you would make, or evidence if you think it's going to be needed, or perhaps be ready for the judge to tell you, I want to hear some evidence. And the judge is going to sit there and say, not take a half hour and go and prep your client. What the judge is likely going to tell you is, why don't you put your client on the stand and let me hear what your client has to say. Do not panic when that happens. This is a very informal evidentiary hearing. The rules of evidence apply, but ... If you're fumbling around, I am likely to rephrase the question for you, or ask you to rephrase the question. And I might say, counsel, why don't you ask about this? Or if the other side makes an objection and say an objection should be sustained, I'll sustain the objection, and then I'll explain it to you with what I hope is going to be enough information that you'll be able to reframe it to meet the objection. That's why these hearings are such spectacular opportunities for you to cut your teeth, because the judges will not sit there and be martinets and simply sustain to make you look like idiots. That's not what's going to happen. We know that you're doing this on very short notice. We know that you're doing this without having thought through in any great detail all the potential evidentiary issues. What I want to know is, what are the facts? And so it's going to be a work in progress. And frankly, I do it for both sides. It's not just for one side. I do it for both sides when I have an informal hearing such as this. So again, don't get flustered. Don't get nervous. Don't let the nervousness interfere. You're always going to be nervous. I'm always nervous when I do something new. But don't let it interfere with your performance. There's plenty of safety nets in that courtroom. And your client sitting next to you could never do what you are doing. And you need to understand it. Motions to continue. I don't think you need a limited appearance representation for the sole purpose of asking for a continuance, except in certain cases. You may find that you've met your client and you think that your client has some medical or emotional disability. Then a motion to continue may be the most critical thing that you can do for the client to get the case stopped so that the client can be evaluated or put into connected with someone who could perhaps formulate a request for reasonable accommodation if one is needed. Now, the judges in the housing court see a lot of cases where there are unrepresented tenants, sometimes landlords, who we think have an issue that might entitle them to reasonable accommodation. I don't wait for someone to stand up and say the magic words before I will step in and make some inquiry. You, as limited appearance doing a limited appearance representation, if you can get the continuance simply to allow the process to begin, a referral to the tenancy preservation program, for example, then you've done a good day's work, because you've at least put into place a process that might, at the end of the day, save the tenant's tenancy, or else give the tenant time to relocate to someplace that may be better suited. So again, you need to evaluate carefully what it is that your your client wants, but also how to get there. But simply a continuance because the tenant's not ready for trial, probably not going to go very far if the Thursday's the trial date without some other good justification for it. Hugo, you can interrupt
Sure.
anytime you want to, because I usually then send them back out to
Okay.
Hugo to talk. So,
Absolutely. Let's see. Maybe if there's any questions first. I'm not quite sure yet of the level of experience in the room in terms of, if anyone's relatively new to landlord-tenant law or if everyone's, for the most part, already trained. So who's new or considers? Okay, so maybe a third. All right,
any questions?
Yeah, please.
I'm just curious, I mean, when you have these situations with a summary judgment or even, a dismiss, I can see it, a dismiss situation, where you lack the evidence, and you know it's there. I mean, you lack the physical document because
Absolutely.
the litigants don't know to bring what they need to bring.
Right.
But you do, I mean, in that situation.
I mean, certainly if you have a compelling piece of, your client says, I have this piece of paper at home, you can always ask the judge for a continuance on that basis. They may say yes, they may say no. As a backup plan, you can always have your client testify as to, the existence of a document or something of that nature. Yeah, that's...
And then that jumps forward to the later stages too, where you might be looking, maybe you hop in and just a little bit of discovery was done of some sort.
Sometimes, yes.
And it's in the file then, it's all in the file there.
Yeah.
If you have that situation, before you come into the court, have your client sign a simple on yellow pad affidavit that says, I have this document at home. Again, depending on the circumstance, I may let your client run home and get it. Come back at 2 o'clock or come back the next week. Nothing lost, nothing gained. Potentially something's gained, but nothing's lost by asking, and the judge says no. So, other questions? Yes?
Yes, having not quite gotten this far procedurally to a motion to issue execution, but been closely, how do you determine, and does an advocate have to ask for an evidentiary hearing before the motion argument? How does this work?
All right, procedurally, if I have a motion to issue execution and I have 2 unrepresented parties, almost always I will just have my clerk swear in the 2 sides. Even though what I may get is argument, somewhere in the midst of that argument may actually be some facts. So at least I'm taking the testimony, very broadly stated, under oath, so that I can consider it. You as advocates, if you're standing up and you're making a argument to me, there's no testimony there. There are no facts. So if you think that I need facts, if there's something that's in dispute, typically a lot of it isn't going to be in dispute. Often what you're asking me for is equitable relief based upon agreed upon facts. So I can just hear your argument. But if there's something that's actually disputed, you simply tell the judge, Your Honor, I'd like to put my client on. I'd like you to hear testimony from my client on this. Fine. I'll ask you can question your client. But you need to, don't presume that the judge is going to simply go through all that and do it for you. The judge may just hear you, hear the other side, and then will just make a decision. May not be the best practice, but that's what sometimes happens when you have 180 to 200 cases on the list. Again, don't be shy. Ask for what you want. Other questions? Yes, sir.
Easy question for Hugo. If we're new to this area of law and we want to either do housing court for a day or pick up the LAR for a specific issue,
Absolutely.
wait 2 months and do the next training with you folks and then get in the process?
If you're eager to get started, talk to me after the training. I can send you some materials. I can also point you to a wonderful training that Judge Winnick did here at the BBA a few months ago. That's on video on our website, and that would be enough for.
I'll probably follow up with you afterwards.
Great, fantastic.
let me go through a few more the type of LAR cases you may get in the housing court, so that you think them through. Preliminary injunctions or applications for a temporary restraining order. The temporary restraining orders that we get typically are the truck is coming tomorrow, or the day after tomorrow. The summary process is has run its course, and here comes the truck. Those are terrific opportunities for limited appearance representation, for you to get up, stand up and make some arguments, because almost inevitably the arguments are mixed. They're both legal and they are equitable. The equitable piece is, my client has 4 kids, they're in middle school, the truck's coming tomorrow, I have nowhere to go. Think through what it is you want the court to do. Legal could be, this was the when the 48-hour notice came, it was the first time that my client was aware that there was an eviction action. And then what you're trying to do is get the judge to put the brakes on so you can have your client file the motion to vacate default judgment that wouldn't be heard until the next week at the earliest. But when those come, you're under serious time constraints, and you have to be ready to make the specific argument. It's rare that the judge is going to hold an evidentiary hearing on an application for a temporary restraining order. The judge will listen to your argument and review whatever the affidavit is that's presented with it. If you're there, sometimes the other side is not going to be there. And you should understand that most judges hate to hear ex parte motions. I probably shouldn't speak for all my colleagues, I'll keep it to me. I hate to hear ex parte motions, but sometimes you just can't get around it. So explain to the judge why it's important that the judge hears the case ex parte. And the relief that you ask for the judge, make it as narrow as you can, given the fact that the other side has not been heard. Even if it's, judge, just stop the truck until 10 a.m. tomorrow, when you can try to get the other side into the courtroom. So think through what you're doing. Also, in LAR, it may be that all you're doing is getting the brakes put on, but you weren't intending to come back the next day to actually argue the remainder of the motion. If that, in fact, is the scope of your limited appearance, make sure that that is clear both to the judge and to your client, so that there's no misunderstanding that the client's coming back tomorrow, but the lawyer isn't, because with the lawyer's scope of representation was just to give the client an opportunity and time to be heard. That's a perfectly appropriate limited appearance action, but you need to be clear. I get lawyers on motions to waive appeal bonds. Trials taking place, judges rendered a decision, it's adverse to the tenant. The judge finds that the tenant owes $3,000. Tenant files an appeal within 10 days from the judgment, and the court is obligated by statute to file an appeal bond unless the tenant moves to waive the appeal bond. And the appeal bond is by default the amount of the judgment and any intervening rent. So you may get a case that you pick up on the day of the hearing where the tenant is seeking to waive the appeal bond. 2 issues you'd have to prepare for. You have to show that the tenant has a non-frivolous issue to raise on appeal, and the tenant is indigent. A non-frivolous issue to raise on appeal is about the lowest threshold that I can think of, but you still have to say something to do it, and all you'll have to work with is the judge's written decision. But be ready to at least articulate what the issue that the tenant would raise on appeal, if given the opportunity, and frame it in some way that all you have to show it has some chance, even if it's an improbable chance, on appeal. And then the second piece is that they are otherwise indigent. Indigent is statutory, and the volunteer tables have the standards for indigency for families 1, 2, 3, 4, 5 size, depending what it is. And have your client fill out the affidavit of indigency. You might get that motion coming in. The last thing you may do in the court, and frankly I think this is the most fun to do, is there is a trial scheduled for the Thursday. And the tenant wants you to enter a limited appearance representation to conduct the trial. Now, trials on Thursdays in the housing court, I will never hear a trial that will take 2 hours. For the simple reason is there are enough minutes in that day to hear the case. I'll hear trials that take 15 minutes or 20 minutes, but if it's longer, it's not going to happen. But you may find that you're introduced to a client who has an eviction case, simple issue, maybe 2 issues, tenant's there, the landlord's there, and everybody's ready to go. No justification to continue the case. That may be a wonderful opportunity for you to stand up and conduct a simple trial. 2 witnesses, 2 or 3 documents, maybe an objection, and an argument at closing. And you've now conducted your first trial. Just something to consider. It's very frightening for someone on almost no notice, and typically if it's going for trial and you accept to do it, and it's going to be that day, if it's 11 o'clock, I'll say come back at 2 o'clock. So you're going to have 2 hours to prepare. That's also can be within the scope of a limited appearance representation. Now in the housing court, we have there are 2 standing orders, just want to mention very briefly to you. The first one is the limited appearance representation standing order, which we mentioned earlier, that just enacted the SJC order for the housing court. And that they talked about it the first part of the session, and that just is the implementation ordinance. But we also have a standing order that dates back to 2001, before there was limited appearance representation. I think it's standing order 1-01. I think I asked you to put it into the materials, and I think it is in the materials. That was when we were first starting with the Lawyer for a Day program. And what I put into that standing order was simply that if a lawyer for the day, when it said that lawyer for the day can counsel litigants, go to mediation without having to enter appearances. The order also said that if a lawyer for the day agreed to enter an appearance in a case that was otherwise scheduled for trial that day, the court would grant the lawyer a 2-week continuance. If you put those 2 together, and of course the 2001 standing order doesn't mention limited appearance representation, because there wasn't any limited appearance representation. And reading it today, I realize we may have to start to make some amendments, because it simply says if a lawyer enters an appearance for an otherwise unrepresented litigant, you're entitled to 2-week continuance. It wasn't intended to deal with motion practice. It was intended to deal with full appearance for trial. But if you as a enter a limited appearance for the sole purpose of trying a case that's ready for trial, nothing else is happening, reading the 2 standing orders together, I would believe that you'd be entitled to ask me for a 2-week continuance, if you wanted to, so that you can prepare for the trial. I hadn't actually thought about this until about 3 minutes ago, so you're getting my very first impressions on this, but I do believe that if you tell me, Judge, I'm entering a limited appearance, I'm willing to try this case, it's all ready, so we're not dealing with other motions, but the scope of my representation is going to be limited to the trial. I'm not going to be representing the client post-trial motions or otherwise. And that's clear, and your client signs on. I think under my older standing order, you can ask me for 2 weeks. Then you'll have 2 weeks to prepare for the trial. But sometimes it's okay to actually try the case that day. It may not be, it's 7 questions you need to ask one witness and 12 questions to the other witness. And you've then conducted your first trial. Other questions? Yes, sir.
Now, in the housing court, in my experience, there's mediation that you get referred to pretty much automatically. But I always see maybe some more experienced lawyers than me who seem to be able to get their stuff heard faster in front of a judge without having to go through mediation. Are they stipulating themselves out of it? How do I get out of the mediation if I just want the motion heard? The other party, we're not going to get anything out of mediation.
You just tell the clerk, I don't want to go to mediation. In the housing court, you should know this as part of LAR representation, mediation in the housing court is not mandatory. The way that you hear coming out of some people's mouths may sound, because everybody's moving so fast, it may sound like it's you have to go. Anybody can say, I don't want to go to mediation. The court has to honor that. So if you want to get a motion before the judge that day, if the motion's scheduled, you want to be heard, and you don't want to just go downstairs and wait 2 hours, you simply tell the clerk, I don't want to go to mediation, I want to be heard by the judge. The clerk will simply say, stay where you are. After we sort the cases out among the 3 sessions, we'll start calling motions. So the people who get their motions heard are those who just haven't opted to go to mediation. One other piece I want to talk about is the withdrawal of limited appearance representation. You need to be clear about the withdrawal. You're in until you are out. It may seem like an obvious statement, but it sometimes gets lost in translation. Once you've finished your oral argument, if it's on a motion, you have a choice. You can, at that point, now that you've made your argument, simply file your notice of withdrawal. Make sure your client knows that you filed it. And what the court's going to do from that point on is, when the judge makes a decision, if it's in writing, the judge will send it to the litigant, and you will not receive a copy of it. So you need to make sure that you counsel your client to be looking for the court's decision, looking for the envelope, and if they don't receive it within some short period of time, to inquire with the clerk's office as to whether the motion has been decided, because you'll be out of the loop. The alternative choice that you can make would be to keep your appearance in until the decision is rendered. The court would send the decision both to you and the litigant in that situation. But when that happens, you need to remember to file your notice of withdrawal once you get the decision. Because again, you're in until you are out. So you need to be careful with the paper. Don't just leave your notice of withdrawal on the counsel table. Make sure it's given either to the clerk who's in session, or down on the 3rd floor in the housing court to the clerk's office, in the clerk's office. Frankly, it's better practice on a Thursday, even though my session clerks hate it, it's probably better if you give it to them in the courtroom, so it's physically there. But you need to make sure that that happens. And that's the point after you finish your argument where you need to decide, have I completed the scope of my representation? And when you do that, if you've made the decision that you've finished, you need to speak to your client. Actually, it's good practice to speak to your client to advise them of, one, you've withdrawn, two, what that means. And you can never be too obvious. It means that you're going to have to come to court and represent yourself for the next event. The notices are going to go to you, and if you want the court to do something, you have to file the papers with the court. Make sure the client understands that. Always end those conversations with your client. Do you have any questions for me? And sometimes it may be prudent to ask the client, what do you understand is the next thing that's going to happen? Just to test that your client is understanding what it is that you are communicating to them. You may think that you are communicating with precision and clarity. The client may not be focusing at all on what you've said. So just test it. Simple questions, even if it's active listening, to get back from your client a reflection of what you've said to confirm in your mind that they get it. I think that that's the best protection for your client. It's also will, I think, give you peace of mind to know that there's no area that hasn't been covered. There's not going to be a cloud that somehow covers something that's important. Deadlines. Make sure your client understands. If you've agreed to limited representation in the housing court for one thing, what happens next? If what happens next is you have to be back in court for trial next Thursday, make sure the client knows that. If it's been a trial, the client needs to know that they only have 10 days from the date that judgment enters to file an appeal. And that 10 days runs from the day that judgment enters, not from the day that the tenant gets the judgment in the mail. There is no presumption of 3 days for mailing for computing the 10-day appeal period. They need to know that. If you've represented a client on a bond hearing, typically the statute says that the bond has to be posted within 5 days from the decision. More typically, the judges give a date certain when the bond has to be posted and what happens if the bond isn't posted. So if you have a client on a bond hearing, make sure the client knows what to be looking for. Because if the judge does waive the bond, but the tenant's still required to pay rent for use and occupancy, they have to do that, or they're subject to having their appeal dismissed. Things that they need to know. Now, you're not going to know everything, and you're not going to know to counsel your clients about everything. One thing that you might want to do is simply confer with one of the volunteer lawyers at the table before you let your client go. Is there anything else that I should be communicating to my client before you withdraw, or what the impact of the withdrawal of appearance?
since the limited appearance representation has been going on, it's been my experience that those lawyers who have done this have left their clients in much better position than they found them. That the clients understand that the clients can go forward. And sometimes that same client's going to come back in 2 weeks, and there'll be another lawyer who's willing to enter an appearance, a limited appearance on their behalf for the next event that occurred. It's not the most smooth ride for the litigant. It's not the most smooth ride for the court to have new people coming in who weren't here when we had the same conversation 2 weeks earlier. But again, what you need to understand from the judge's perspective is I'm okay with that. I'm not going to penalize you because you weren't here 2 weeks ago when someone else was making an argument. I'm not going to get impatient because you're bringing yourself up to speed. I want you in my courtroom. You're providing an important service to people who need your service. So it sometimes takes more time. It's sometimes not particularly efficient. But in the back of my mind, and I think the back of your mind, the bottom line is that you're trying to be just. You're trying to be fair, and I'm trying to get to the right result. And anybody who can help me get to the right result, I'm going to be very appreciative of. So this is not something to be concerned about. You don't have to be apologizing to the judge, though it's sometimes nice for you to say, Judge, I hope you'll indulge me a bit. I just got here, and I understand that there were matters that took place beforehand, but I've only just recently tried to bring myself up to speed, and I'll sit back and give you a chance. Because I do respect what it is that you've agreed to do here. And frankly, you're doing good work, and you're gaining something from this. You're getting some experience that I can't imagine how else you would get. And all you need to do is stand up and argue a contested motion in the housing court one time. The second time is going to be a whole lot easier. And by the third time, I'll recognize you, so I'll be pushing you more, and be expecting more. But this is how you get experience, and this is how you make yourself more valuable to your clients. I do want to talk about one other piece in the housing court that I don't see it because of the way that the LAR cases come in with a whole lot of regularity, but it's still out there. Some of you may be building practices, and building a private practice on your own is not easy. In housing law, there are claims that are statutory. Claims for a breach of quiet enjoyment, security deposit statute violation, 93A by way of example, where a lawyer, the client's entitled to a reasonable statutory attorney's fee if they prevail. You may find in your in your representation, you come to the housing court to do LAR representation as a volunteer. You may agree to take a limited appearance representation on a motion for a client, and in further talking to the client, you discover that there may be a claim that would entitle the tenant to request a statutory attorney's fee. As I understand LAR, you could negotiate with the client and agree to expand your representation. In which case, you may find yourself on representing a client who may have a quiet enjoyment claim that statutory damages, 3 months' rent if the actual damages aren't greater. But if you have a trial and you prevail, and you have a 4-hour trial, you may find yourself that you'd be entitled to be compensated at prevailing rates. There are some law firms I'm aware of, especially out in Western Mass, or a few in Boston, that built their practices doing nothing but statutory fee landlord-tenant cases. I'm not saying that that's necessarily as doable now as it was 20, 25 years ago, but it certainly is something that is out there. So I want you to be aware of the fact that there is that potential as well. You obviously have to deal with certain ethical issues and how you engage your client and what the conversation is, but those are conversations that the parameters you can discuss with the Boston Bar Association when you're taking those cases. But that is a possibility for you. I think that I have said everything that I'd like to cover, but is there anything else that anybody wants to ask?
I'm just curious, in terms of when you're doing the motion sessions, or and you need to, you obviously need to write something up. Do you have forms that are provided to you when you come in before you get into the courtroom?
Absolutely.
Or is that
If you're practicing with pro bono with a volunteer lawyers project, we have a whole rolling cart full of indexed pre-printed forms, which are, I think, mostly of good quality, and the court's familiar with most of those. So we have a lot of those. We have a library there, and of course there's also blank forms or forms that you can modify by hand. And due to the quick nature of summary process cases, I've seen plenty of agreements for judgment or other or motions where there's an extensive amount of chicken scratch involved. Yeah.
Let me explain to you how that works. It comes in 2 forms. A unrepresented litigant goes to the volunteer lawyers table. They help them fill out these forms. And the lawyers, volunteer lawyers, tell the litigants when they go into court, give these to the judge. What happens is they have this handful of paper in their hand, the case is called, the litigant is sitting there, and the litigant never tells me, I have these motions I want to give you, these papers I want to give you. What I do is when the unrepresented litigant comes to the table, I look to see if they are holding anything. And then I will ask, is there anything that you want to give me? And they'll say, oh yes, I want to give you these. Now, if I just looked at them and asked the litigant, all right, I see you filed a motion to vacate default. What do you want to tell me about that? They'll tell me nothing. I'll have to frame a better question to ask them. If the volunteer lawyers or LAR lawyers come in, they'll do the same thing, and frankly, half the time the papers are still sitting in their hands until I ask them, do you have any motions you want to give me? So I will take them. Lawyers on the other side get upset that they're seeing the motions for the first time when the motion, in the case, has been called. I'll simply ask the lawyer on the other side, do you want to take a few minutes to look at the motion? If so, I'll put it on second call and then argue the case. But you're not going to be expected to draft on your own in 2 minutes pleadings. And I just don't think that's realistic for anybody. Your other question you're going to ask?
I'm sorry. Yeah, no, because I know I do lawyer for the day in the family court side, and I know that there's some courts that prefer you to make sure that everything is typewritten out versus those that really prefer you to you could just handwrite them. And I just didn't know, and I even know some lawyers that come into court with jump drives and give them to the clerk and have them print out.
I have gotten motions on napkins. I have gotten motions, actually I got one on the back of a banana, believe it or not, where you have to be flexible. You have to be flexible. Other thing, I keep thinking of things, you keep me here long enough, I'll just keep talking and we'll just have dinner together. Language. You are going to find that in the housing court there are litigants with a vast range of foreign languages. The trial court has professional trained interpreters who are excellent. The jobs they do, I could never imagine being able to do the work that they do. It's extraordinary. But you're going to find litigants who need lawyer for a day, LAR assistance, and they don't speak a word of English. That's only going to it'll make your work more difficult, but not impossible. You're going to have to work through an interpreter. Now, either there'll be people at the volunteer table who have the language skills, they'll be able to interpret for you, but they're not going to be able to do it in the courtroom. I'll only take interpretation from the court interpreters. So if you have a client who speaks Vietnamese and you can't communicate with the client, an emotion is coming on, come in with the client and tell me that there's a language issue. Spanish, I can usually get an interpreter in that day. The languages that appear less often, I would typically have to make a request for an interpreter. That would be another reason to ask for the case to be continued. But you need to identify what the language needs are. You need to make some effort to find out whether there's any availability. And it may mean going to the clerk's office and finding out whether there's an interpreter speaking that foreign language on call in the court that day, or whether one has been requested. So find that out. I'm very sensitive to that. I will not go forward on a case with a litigant who I think cannot communicate effectively with me. And it's important for you, not just in the courtroom, it's important for you as the lawyer to make sure that when you are conversing with your client is accurately and completely providing you with factual information. So don't let the client stumble. If you're having difficulty, ask for assistance. Go to the table. See if you can get assistance. If you can't get it because they don't have the language, then talk to the other side, see if you can perhaps get a continuance. Always ask the other side before you come in to see the judge. But if they're not being cooperative, come in and see the judge. Absolutely critical to do. And you'll find that if you have an interpreter, it will enhance your ability to get to the bottom of the case and to identify what your client wants with clarity. So don't be put off by the fact that the client doesn't speak English. Just use it as another hurdle that you need to get over. But it happens all the time in the court.
And in fact, Volunteer Lawyers Project, being aware that the interpreter provided by the court is generally highly trained and, in my experience, very professional and very good at what they do, they're not generally obligated to help the litigant converse with you outside of the courtroom. They're only required to help with the actual hearing. So sometimes some of them will informally come out in the hallway and maybe help you out a little bit, but if you need help and you're volunteering with us, talk to me. Volunteer Lawyers Project now has a new contract with a telephone interpretation service that can do any language. They even have miracle workers, I don't know how they do it, who can somehow figure out what language someone is speaking without without, even if you don't know what it is. So they can do a pass the telephone thing, or if you have two cell phones, you can have them simultaneously interpret for you and your client, so that you can at least get a sense of what's going on and have that conversation.
I've always believed that the practice of law is a profession, it's a calling, it's not simply a business. I think that we're all honored to be able to practice in the bar. I think that with the power that we have comes great responsibility. And I can think of nothing more important as lawyers than doing justice, helping people who really need your help, who are often on the margins and are forgotten, and if left to their own, would not be able to navigate our legal system. I think that the work that you're going to do, you come into court and you spend the day in the housing court and the probate court, you're going to come away feeling better about what you're doing professionally, and I can't think of anything more life-affirming than the thank you that you get from a litigant who had nowhere else to turn. The fact that you're all here tells me that you share that, and I'm very, very pleased that you're doing this, and I want you to know that from the court side, I want to thank you all for doing it. What you're doing is important, and what you're doing is, I believe, critical to what our profession is about. So thank you. Anything else? With that, I think we will recess. Now I expect to see you all.
Thank you, Your Honor.
My pleasure. Oh, well, that's...
Yes, please, that would be wonderful. And, okay, great, so you're a staff attorney at the Yale. I can contact you and I'm just trying to, I know I'm gonna file this case, and so I want to get it as soon as possible, because I do the probate family, I'm a divorce lawyer, but, I want to do some in the housing because of this motion stuff. I like that. I'd love to do that. You know, having a litigation background. So my name is Amber Beavers, and I don't have my card on me. I used them all earlier today.
It's a good thing to have.
I know. So what I'm going to do is everything email you.
Yeah, there's nothing to do it. I think
Very
you've just done it.
memorable.
Absolutely.
Okay.
Nice meeting you.
Nice meeting you.
They mentioned, like, you know, probate family court,
Oh,
there's
you
a
got
whole
it.
thing like in the packet.
You got to tell him. I haven't a clue.
That's all right. Fair enough. Thank you.
Oh, absolutely.
I used all my cards. So I just give you.
And will you be doing, whoops, I'm sorry, will you be doing a training at some point?
Yeah, in about 2 months. We had one just last week, and it's on an every other month cycle. But we also, I mean, if you're eager to get started and you want to jump in and use the stuff that you saw still fresh, as I was telling the other gentleman, I can forward you some self-study material, and I can go over some of it with you, and also point you to a video recorded training where, as you can see, the judge is extremely knowledgeable and well organized in his presentation. So that's always
Your personality is going to determine how you best.
Oh, perfect. All right.
I got a question for you. So certification, you've done this program, so we are certified, but like paperwork-wise, I noticed they mentioned downstairs, like probate family court, there's some forms that you
And
can
they're
fill out.
all in this
I didn't see
green
any
book.
for housing
The
court.
only way
well,
that you learn
you
how
know what,
to study evidence all you want.
Part of that is
I teach
because
evidence,
the housing court
but
very efficiently
evidence is different in a court.
and in my
Evidence
opinion wisely
is intuitive.
says that you don't have to pre-file any
Prepare
certification
and
that
identify
you've done the
where
training.
they're going to be evidentiary.
All you have to
You
do
need to carry around like a certification
Nope.
with you just in
An
case.
address
they ask
is
for it
ready
or
That's one of the great things about
But
housing court. It's
always
purely
better
on
to
your,
use
Scout's honor.
that tells
When you
you,
make your notice of
hearsay?
limited
Is it,
appearance,
is there a foundation
which
for it?
I think is one of the handouts downstairs, separate from the
It
book.
just has a little statement in there that basically says, hey, I'm
But I haven't
certified.
seen
Exactly.
anybody
I've been certified.
collapse
Exactly.
on
I
their
believe
feet,
it's,
faint. So it's
um,
and it's fun, frankly. I'd rather be in the courtroom than anywhere.
I
That
further
gives
certify that I'm in
everybody-
compliance with the requirements
Don't
of
be intimidated.
Standing Order 1-10, so, I mean,
Yeah. So when you do it,
exactly.
perfect.
Yep.
It's less paperwork to worry about, less stuff
beautiful
to
thing.
send in, less stuff to fax, that's
More time to spend
perfect.
in the
And also, I mean,
Thank
if you
goodness
happen
for
to,
the housing court.
right, if you ever want to do LAR in the BMC or
It's like
family
anything else,
probate
it's,
or,
this is your stage.
or land court,
And
you
once
know,
you
they have
understand
their own forms.
exit right, exit
Generally,
left,
those are pre-certification, but
when
those
you
are all
stand, when
available
you
here
fall,
and on the
when
court
you're not.
system's
Once you get all that
website. It's
stuff down,
pretty
then you
Okay.
easy
can
to find.
spend
And
time.
if you have any problem locating any of that or have any questions, always
Yeah,
feel free to
yeah,
ask me.
email you, perfect, thanks a
Great.
lot, appreciate it.
Did you get the answer?
I did.
Yeah.
Housing court, amazingly efficient.
Absolutely, yeah.
Not a lot of paper.
Yeah.
Sure, that'd be awesome. Fantastic, thank you.
Take care.
Hey,
Hi, let's go
My
ahead.
pleasure.
I'm Adam Kavanaugh. I actually sent you an email, I think, this morning.
Oh, okay, great.
Uh,
I'm
so-
sorry I've been.
Thank you
Oh,
very much.
nice to meet you. I apologize, it's been a totally crazy
Oh,
day.
not at all. Yeah, no, it's totally fine. I didn't expect you would get back to me anytime, today. So, but I wanted to talk to you because I'm very interested in getting into the Lawyer for a Day program and other opportunities to do
Good to see you.
pro bono work and potentially LAR
Yeah.
work, but I have no courtroom experience. I'm looking
Sure.
to get that experience.
Yep, most of us came into this not with
Yeah.
any prior court
Right,
experience to
right.
speak of, so, yeah, I think it's a great opportunity, and, in addition to our Lawyer for the Day program, we do have, full representation cases where we keep a mailing list of attorneys who are interested in, whatever categories, housing or family or whatever.
Mhm.
Our referral coordinator emails a weekly list of cases that are available, and if you're interested in something a little bit less hyper speed paced,
Yeah.
and more, considered, then that's another option as well. So both, or you could do both.
Is there an opportunity for me to jump right into the fire this Thursday in the trial room? Allison from
Yeah.
earlier told me to ask you that and said that
I
let
would-
you know that she
yeah.
said that, but I didn't know.
Do you have a chance to attend one of our trainings yet, or as far as substantive housing?
I have not.
Okay.
No.
I'm happy to forward you some of the training materials and point you to a roughly 2-hour YouTube video where
Yeah.
Judge Winnick is actually, presenting a lot of the material, and,
Okay.
and that should be enough to, at least know what you're jumping into.
Yeah.
And absolutely, if you're raring to go, then we can do our best to find you a case that's a good fit on
Yeah.
Thursday.
Perfect.
So-
Okay. Well, yeah. I guess will you need to send me a link to that YouTube video, or is there a way I can just write it down and pull it up myself and let you know I've watched it so that we can?
Good question. I don't remember it exactly offhand. I know there's a link on our website, but our website's not the best organized. So feel free to just shoot me an email if you'd like, and I can, or I know you already did this morning.
I did.
So
yeah.
as
But
soon as
yeah,
I get back to
shoot
the
you
office
another one
tonight.
just so you remember
Yeah.
who I am. I know you're meeting a lot of people today, so I'll send you another email and I'll just request the YouTube link and I'll watch it and then
Fantastic.
do I just I guess you'll get back to me and let me know when I can come on Thursday, or should I just show up and?
Thursday, we're there from about 8:45 until 1 p.m.
Okay.
8:45 a.m. And are you admitted to practice in this?
Mhm.
Great. Okay.
Yeah,
So
I just got
that
my
should-
bar card in the mail.
Lovely.
Got
Great.
it laminated.
So you don't even have to, you can skip the security line if you waive that card.
Right,
too.
okay.
So that's good.
Okay, and where is the
It's
where am I
at,
going?
what is it,
Chardon Street.
New Chardon Street, the
Near
notice-
Haymarket.
Yep.
Are you
it's-
driving?
I'll probably take the T.
Yep.
Haymarket,
You know
okay.
what, I have it written down on this handy,
I'm sure it's on the
Pretty good.
website. I can look up the exact address.
134 New Chardon Street. And I'll email you a copy of this as well, but just so that you have it in hand.
Okay. Great. So if I actually participate in a trial on Thursday, will I be in front of Judge
There's
Winnick?
3
Winnick.
judges that are regularly there with the Boston Housing Court. There's Judge Winnick, Judge Muirhead, and then Judge Pierce, who's the Chief Justice of the overall state
Okay.
court. Occasionally puts in some time as well. So.
Great. All right, great. Well, yeah, I'll follow up with you probably tomorrow morning or
Great.
something, and look forward to seeing you on Thursday.
Looking forward to it.
Cool. Good to meet you.
Yep, same here.
Take care.
You want to walk?
I think they're good.
Oh, it's totally better than sitting in a small room somewhere. And that's what I did for 2 years, but I'm on my way now to learning, and I'm real excited.
Well, hope to see you in the court.
Yeah, me too. Thank you
Take
so
care.
much. Thanks for chatting.
This is supposed to just zip right back up.
How long were you practicing before you became a
I
judge?
was much longer. I was a law professor for a lot of years at BU Law School, and I left the BU to join a friend of mine in a boutique law firm. We were doing a sort of high-level real estate practice, and I was there for 7 years. And it was from there that I went onto the bench. That was back in '95, so I've been here for a long time.
Yeah.
It's the longest job I've ever had.
Yeah, I'm in my own mind torn as to which path to take. I told you I'm interested in the public defender's office, but I'm also, my background is in real estate, so I've been interviewing with a lot of closing attorneys to get in the door that way. And,
Yeah.
you know, I feel that the more rewarding work will probably be, working with the public defender.
Well, I mean, if there's a job, I mean, again, it's the economy that's driving everything.
Yeah.
I think that out of law school, early on, you take the first job you get.
Yeah,
Because and then start to build from there. Because if you wait for the ideal job, there's no guarantee. But the real estate market is starting to improve. So you may find that there actually are law firms that are looking to hire.
Yeah.
There are a lot of law firms that appear in the housing court that do represent banks, represent, and that may be an entree also. It's not necessarily representing what's perceived as the more needy side of the equation. But again, it's experience, and you're starting to learn.
Right.
The PD work, if you want to be a trial lawyer, no better place to start out than the public defender or the prosecutor's office.
Yeah.
Because you're on your feet every day.
I feel I'm struggling with the hurdles of getting a position there because I actually graduated from law school in '09.
Yeah.
And I've been working really on the business side of things as in-house counsel without a lot of legal experience that allows me to write a compelling statement of interest to
Yeah.
let them know that I'm not experienced working with the indigent population.
Yeah.
How do I,
That's hard.
Yeah.
And you're doing what you're doing, so you have a 3 years resume, so they're going to see what you're doing, and they're going to ask you, well, why this now? You have to have an answer for that.
Yeah.
And if you get through the door, then you'll get a chance to do it.
Yeah.
Take care and good luck.
Yeah, you too. My name's Adam.
Adam, nice to meet you.
You too. May see you on Thursday. Kind of get into your courtroom.
Hope to see you.